In my view, there is never a wrong time to mediate. So you can mediate at any time. But I think the more pertinent question is, when is the opportune time to mediate? And that may well depend on A, the nature of the dispute, and B, the nature of the parties to that dispute. Let me explain by some elaboration. If, for example, you have a commercial dispute and the matter is perhaps at a very preliminary stage where parties are exchanging lawyers, perhaps amongst themselves, maybe even between lawyers appointed for the parties. In such a situation, the question you've got to ask yourself is really whether the disputes between the parties have been articulated to an extent that parties understand and appreciate what each of their interests are in that dispute. Because if you do not have a good appreciation or understanding of either party's interest in the dispute, it will be difficult to mediate that dispute. So in a commercial matter, one of the opportune times to refer the dispute to mediation would really be when parties have appointed lawyers, they've started pleadings, they've filed a claim, there is a defense, maybe a counterclaim, there is then a defense to the counterclaim and possibly a reply. And what happens at that point in time is that the issues between the parties are crystallized. And therefore, parties have a good sense of what is the interest each of them have in that dispute. However, that may not work in all circumstances. For example, if you have a family dispute, ventilating that dispute in court through pleadings may be a source of irritation to the parties and may end up irretrievably destroying the relationship of parties. So one of the things that you as counsel or one of the parties may wish to consider is if the nature of the disputes is such that there are sensitivities involved which could damage relationships beyond repair by merely the articulation of those issues, then perhaps the mediation should be held even prior to the filing of a claim in court and the close of pleadings. So there is no one answer to this question. It really depends on your assessment of A, the dispute, and B, the nature of the parties to that dispute.
There is never a right time to mediate in that manner. Or rather, not so much whether there's a right time to mediate. It is never too early to mediate, but it can be too early to settle. And that has always rang, it's always had a resonance with me. Because from what Samuel had said as well, it may be a situation where I get into the mediation and I initiate the mediation. I started at a very early stage, even pre-writ and pre-commencement of proceedings, because I want to avoid having that adversarial setting. I want to avoid a situation where families are pit against each other. I want to avoid a situation where long-time business partners are made to accuse each other of being liars or cheats or fraudsters in court. And going to mediation early avoids that scenario. But the parties may not be in a position where they are able to ascertain for themselves, is the proposed term of settlement, are they fair? Because they may not have had sufficient discovery of documents, documents especially which may only have been solely within the possession of one party and not the other, thereby creating a large negotiating imbalance, power imbalance between the parties in the course of the mediation. And without those valuable information, one of the parties may find it difficult, especially counsels in that mediation, may find it difficult to advise the client on the reasonableness of the settlement terms being proposed. So from that perspective, I think the answer to that from my perspective is there's never too early to mediate, but it may be too early to settle. The other end of the spectrum, is it ever too late to mediate? And again, from my perspective, it's never too late to mediate. I've done mediations where it's after a first instance judgment had been given and parties were pending in the Court of Appeal, for example. And the Singapore courts themselves, I think the judges and also the courts and the Court of Appeal in Singapore have actually come up front to encourage people to mediate even after a post first instance judgment situation. Pending appeal, please go and mediate, and if you can settle it out of court, all the much better.
Have your issues been sufficiently ventilated? This can be either in the form of your papers that are filed in court. What are you claiming? What are the positions that are taken? Then, have the documents been discovered? This will allow you to analyze the reasonableness of what is being proposed. And the result is that you are able to make a reasoned decision as to what is being offered. And then, what is on the table? Are parties ready to compromise? And for that, I would always say, never too late. There we have it. The lawyer brings that calmness to analyze the situation, which may be increasingly emotional and difficult for the other party to accept. So that is the value of a lawyer.
Thank you, Francis. I agree wholeheartedly with what Francis has said. The objectivity of a lawyer in a mediation will be a crucial element in achieving a settlement, if at all that is possible. But in addition to objectivity, can I suggest that the lawyer brings also 5Ks? What do I mean by 5Ks? First K, knowledge of the law that governs the dispute. The second K, knowledge of the procedure that governs the dispute resolution procedure. The third K, knowledge of the client. The fourth K, knowledge of the mediator. And the fifth K, knowledge of the opposing lawyer. Now let me talk a little bit about each of those 5Ks. Knowledge of the law governing the dispute. That is going to be absolutely crucial in putting your client in the right frame of mind as to what he will, may, or may not achieve if the matter goes to court or arbitration and is litigated to the end. The client needs to know what is the end game for him and the risk involved. Second K, knowledge of the applicable procedure. If the matter goes to court, a lawyer will know what evidence is admissible and what evidence is not admissible. That will, to a large extent, determine how and what the client can prove, whether in arbitration or in a court procedure. And that will be critical for a client to be, in a sense, to be informed of what he can achieve at the end of the day if the matter is not resolved. The third K, knowledge of the client. And to this extent, Francis talked about this. The sensitivities of the client, the emotional baggage the client brings to the dispute. The knowledge of all of that will enable the lawyer to manage the client in the process of that mediation. And if the client is not well managed, what could otherwise have been a well settleable dispute may end up going the whole hog. Knowledge of the mediator. When we talk about advocacy and persuasion, one of the key principles is that you must know who you're appearing before, who the tribunal is, or who the mediator is. Because you need to know what are the buttons you need to press with that particular individual, because he is just as human as you and your client are. Some things will work with that mediator, some things will not. So knowledge of the mediator will be a useful tool and element for a party to a mediation. And finally, knowledge of the opposing lawyer. Your lawyer would have, in the course of his experience, dealt with multitudes of lawyers. He will know who is appearing against him. He will know the characteristics of that lawyer, the preferences of that lawyer, the style and the modalities in which that lawyer works. All of that knowledge will help your lawyer present your case effectively in a mediation. That, to my mind, is what a lawyer brings to a mediation. I think the first and foremost principle that a lawyer must bear in mind is that in a mediation, he is not a litigator. Too often, we find in mediations lawyers approaching it as if they are appearing in court. It is not a court setting. And it's important to realize that the function of a role in a lawyer, role of a lawyer in a mediation is very different from the function of a lawyer in court. In court, the lawyer is really an antagonistic opponent. The objective of the lawyer is to put forward his client's case as aggressively and as persuasively as possible to win the day in court. In mediation, the function of the lawyer and the role of the lawyer is slightly different. It is aimed at achieving a resolution of the dispute so that the client does not have to step into court.
I think the biggest key difference would be the fact that in a litigation advocacy, as counsel, I'm advocating a position, a fixed position that I have to produce in court evidence to prove every point, to prove every element. Mediation advocacy, far more fluid. The whole idea is that you don't want to get locked in a position. You want to see what is your party's best case. You want to understand what is the other party's best case. And then you're trying to create movement to try and see, well, it's not necessarily a compromise, but how are you able to move in such a way that you are able to accommodate the interests of all parties? What do you all think?
I think that's absolutely correct, Francis, but can I add a different or maybe an added layer to that? In litigation, we as lawyers, we go to court, we build up our client's case. Then we demolish the other side's case through a cross-examination or through arguments on the law. And then we make the submissions to the court. In mediation, what is missing is the demolition work. You do not, as a lawyer, go into mediation to demolish your opponent. You don't have an opportunity to cross-examine the opponent. You don't have an opportunity to say that whatever his case is on the law is defective. And that's where I think the advocacy is different. Where it is similar is you are advocating, but perhaps in a gentler way, and perhaps with a view to the equities and the interests in the situation, your client's position. So you would convey to the mediator, for example, why your client's position is right or is just, you would convey to the mediator, for example, what is your client's interest and why that interest is deserving of being accorded what the client is asking for. But you will not, in a sense, demolish the other side's position or the other side's interests. Instead, what you would do is convey to your client the other side's perspective and the other side's interests. And hope that by doing that, you get your client to see through the lens of the other side what their concerns are. And with that, get your client to address those concerns and at the same time achieve what your client is trying to do with his concerns. So it's a far more nuanced approach when it comes to the advocacy skills. It's not straight thrust, cut and conquer. It is perhaps presentation with the thrust. Maybe it's a parry. Maybe it's persuasion of what the other side is doing and why they're doing it, and then trying to move your client forward with that in mind, with the other side's interests in mind, and hoping to find a landing that is acceptable to both sides. Firstly, there is the ideal world. Then there is the non-ideal world. And then there is the wholly imperfect world. What do I mean by that? Well, I sit with the client and say to the client, in an ideal world, what would you like to achieve in the mediation? And you heard both, I think, Chern Yang and Francis talk about BATNA, which is essentially the best alternative to a negotiated agreement. It means if all the stars are in the right place, everything falls your way, what would you get? That is the ideal world. So you need to work that out with your client, because in a sense, that world and the position you get after analysis of that world would be the highest that you would look at in achieving a settlement at a mediation. Then you talk to the client about the non-ideal world. You tell the client, we don't live in a perfect world. We live in a world where there are rules, there are limitations on what you can prove in a court of law. There are limitations in terms of the evidence you have. There are limitations in terms of your rights that you can claim in law. And the big problem of the facts. What are the facts? And in a non-ideal world, with all those limitations, what would your client be happy to live with in a mediated settlement? And you'll probably get a range of outcomes or figures. And may I suggest that that probably would be your preferred landing point at the end of a mediation. But the preparation of your client does not end there, because you then have to go on to explore with him the third world that I spoke of, which is the totally imperfect world. And dare I say, that is the world that we live in. Because everything that can go wrong will, according to Murphy's Law, go wrong. So if you have a matter in court, you can expect that your evidence will not turn out the way it should turn out. You can expect that witnesses may not give the evidence that you expect them to give. You may expect that a judge may wake up on the wrong side of the bed and take a completely different construction of the evidence that you have taken. That is the imperfect world that we live in. And in that sort of world, what would be the outcome that you would walk away with or be prepared to settle at? And that really would be your bottom line. In other words, that is the outcome that you will accept as your last resort. Anything less than that, you would rather go and roll the dice and have your day in court.
You know, when we prep for trial as trial advocates, we sit down with the client and we sort of do mock cross-examination sometimes, bring them through the process,
and try to test out the evidence, the veracity of the evidence in chief, in whatever we have already filed in advance, and try to prep the client for that. And from the mediation perspective, I do it the same way. So you prep the client for what very likely can happen in the mediation. So what I mean by that is not just marking out the bottom and the top, the batna and the whatnot, but we go further and we say, this is how we are going to get there. You have what you would like to achieve. Sam mentioned what the ideal settlement terms are, and plot out with the client, how are we going to get there? Is it by making the first offer? If the first offer is $1 million, how then will the opposing party react? Very likely react to that proposal. And based on what we believe their first counter proposal is going to be, what is going to be our next second follow-up counter proposal? What are the various options we can throw in as part of the negotiation package, settlement package rather, in the negotiation process that will move the negotiation process along to be able to help the client achieve that outcome. So having the ability to map out with the clients various negotiation maps. If it's this offer, we will counter with that. If it's that offer, we'll counter with this. And also in terms of disclosure of information, right? Again, in mediation, the key thing in that is the strategic timing of disclosure of certain information. When would you disclose what your alternatives are and how would you frame it? When would you disclose certain perhaps key information, especially if the case is at a stage where perhaps discovery hasn't occurred yet? When would you disclose what could have been a material evidence supporting your client's case? Is it at the start, in the middle, at the end? All these are decisions to be made rather between the counsel and the client, even way in advance of the mediation in the prep, because you need to map out the negotiation process. So that's my perspective on it.
There's one school of thought that we would continue with the mediation into the wee hours of the morning. Okay, and I'm sure we've all encountered mediations of that kind. But I think the more enlightened view is to have a second mediation session, and that is particularly useful in family type matters or in this kind of emotional matters where you want to have parties have a cooling period, okay, as opposed to making a settlement but then regretting it the rest of the life. Okay, so I would say it's not necessarily a bad thing that parties change their minds. I would give them that time to reflect.
I think if I was the mediator in that instance, it's a very tough discussion to make. And I probably go back to one of the questions we discussed, which is what is the value or the role of having a counsel in mediation? And to me, in those instances, counsels will prove extremely valuable because I would then knock heads together with counsels. For example, if it's you and Francis, 3 of us in the room, and say, guys, it's late, it's 11 p.m., all your clients are tired. Do you think you are all right to go? Do you think your clients are all right to go on? And I would rely on that very professional judgment from counsels to give me that indication. To say, you know what, my client, he's really getting too tired with this, he can't handle this, he's 70 years old, he's got medical conditions, he's not prepared to go through this anymore, it's already 11 p.m., he needs his rest. Or in the sense that he's great, let's go down for a beer, after the beer we come up and then we go for round 2, right? So I would take guidance, and that's where the value of counsels come in important for me.
It's really a case where I appeared as counsel. We had 2 businessmen who were once very good friends, as they tend to be, and now mortal enemies. And it involved a deal that either party was accusing the other of going back on and being dishonest on. So in the mediation, one of the options or one of the terms of the settlement was that both of them would go into a well-known temple in Singapore and take an oath that a calamity would befall on whoever was lying in the case. And that is not something you could get as a remedy in a court adjudicated matter. But you can get that in a mediation. Unfortunately, the matter didn't settle. But that was one of the options that was discussed and agreed on in the event there was a settlement. That these two gentlemen would walk to a temple and take an oath before the deity in the temple that whoever is lying would have a grave misfortune befall them.